to welcome you here to the Canberra Business Chamber for our webinar today. My name is Greg Harford. I'm the Chief Executive of the Canberra Business Chamber, and I'm delighted to be joined by Amy Sidney, who is a Special Counsel at MV Law, and Ryan Goldsworthy, who's an Associate in MV Law's Litigation and Employment team. We're here today to talk about wage theft and superannuation theft. Sounds very scary, but we're going to unpack some of the challenges around that and talk about the what it all means and how businesses can stay compliant. Amy and Ryan regularly work with business owners, general managers, HR managers and directors to navigate workplace issues. They help businesses recruit, they help terminate, they help advise on compliance with workplace laws, awards and enterprise agreements, how to conduct workplace investigations. And the key thing they do is provide advice and representation in fair work proceedings around unfair dismissal and bullying and harassment claims, and hopefully not too much in the wage and superannuation space. But it's great having you guys here. Thank you so much for joining.
Thanks, Greg.
Now, there've been a lot of changes to workplace relations laws under the Fair Work Act over the last 18 months or so. The government has packaged up a number of things. They've called the Closing the Loopholes bills, and they've pushed them through Parliament, and amongst other things, they've created some criminal offences around wage and superannuation theft. So we're going to unpack those today. We're going to talk about what businesses need to know in terms of their legal obligations. We're going to talk about changes to the legislation that have come through and how to stay compliant. So we'll have key risks being covered. We'll talk about practical steps, and we'll open the floor for questions at the end. So Amy and Ryan, I'm going to hand over to you to have a bit of a chat, give us a bit of an intro on these issues, and then we'll come back and take some questions at the end. If there are questions that you have, feel free to direct those into the Q&A box at the bottom of your Zoom screen, and we'll get to those at the end.
Great. Thanks, Greg. Thank you very much for having us. We're very, very honoured to be asked. I'm a previous quasi-business owner with my family, and so I understand how important it is to get this information and understand your obligations that can sometimes be a little bit scary when there's so much regulation in the business space. And employment is certainly one where there's been lots of changes in the last 18 months, Greg was saying. One of maybe the most maybe scary changes is this concept of criminal liability coming in relation to wage theft. And so, look, wage theft has been around as a concept under the Fair Work Act for as long as the Fair Work Act has existed, since 2009. But it was historically a civil penalties regime, meaning that criminal sanctions were not applied or could not be instituted if there was an alleged breach of those provisions. But an employee could take an employer to court, to the Fair Work Commission or one of the federal courts in relation to an alleged underpayment. And the Fair Work Ombudsman could also do some investigation into that and impose these civil penalties or fines. But now, since the 1st of January 2025, we now have this concept of the possibility of much, much higher fines, criminal prosecution, criminal liability, and scarily, imprisonment. So the purpose of today is not to scare you, but to give you some information about how to unpack, as Greg was saying, these provisions, to give you more information so that you can work this into your business and be less worried about something that you don't know, and more about being proactive about making sure that you are compliant with these provisions moving forward in your business.
Amy, can I just chip in here though?
Yeah.
I mean, most of the businesses, all the businesses I talk to want to do the right thing by their employees. So everyone is trying hard to do the right thing. It's right, isn't it, that if you are doing the right thing and trying to do the right thing, you're not going to be tripped up. But there's some things you've got to know in order to stay compliant.
100%. So Ryan's going to kind of take us through the provisions and some of the thresholds and elements of the offence. But one of the big ones is, in order for it to be a criminal liability issue, it's about intention. So the current Fair Work Ombudsman, Anna Booth, has recently come out and said, look, business, I know this seems scary, but we are not going to be prosecuting for genuine mistakes. So if you are taking active, honest steps to make sure that you are paying your staff properly, then that will come out in the investigation, and we are not going to be sending that to the AFP or the Director of Public Prosecutions to commence proceedings in relation to a criminal case. So you're absolutely right. Part of it was the reason why this was brought in earlier this year, and obviously it's been talked about over the last 2 years in relation to all of the other provisions in the Closing the Loopholes Act, and it's been one of the last ones to be implemented and brought into effect, because it is one that the Commonwealth realised that business needs to get used to and understand. It was one of the more controversial introductions or amendments to the Act, and so brought in quite late. But it was really in response to some very, very large scale matters. Really one of the most, infamous cases, notorious cases is the 7-Eleven case. And that's really where it kicked off, when the Commonwealth started to go, oh God, this is actually happening. Where wage theft is happening to such an extent that we need to actually bring in a little bit of a bigger stick to make sure that these particularly vulnerable employees are not being underpaid, particularly intentionally, but that they're protected in relation to their entitlements under the Fair Work Act.
And I think importantly to add to that as well, Amy, a lot of those previous cases, they are large scale. They usually involve quite large corporations, whether that's underpayments being made by Woolworths or Coles or Domino's. But it's equally important for smaller businesses to be aware of it as well, because when we go through the provisions and go through the Act, it is very possible for smaller businesses to also be subject to these or breaching these provisions.
Right.
So it doesn't just apply on the larger scale, and the Ombudsman might be more concerned with larger scale breaches as well. But it's very relevant to smaller businesses and small to medium enterprises as well.
Absolutely. And there's nothing that will stop necessarily the provisions from being applied. We will give you some sort of practical steps to take. But still, these provisions, these civil and criminal provisions, can be levied against small business. And in that case, there is a recognition that small business has less resources, I guess. There's usually not a big HR department and things like that, and those elements will be considered by a decision maker, because it's very case by case. There's not a one size fits all, Greg. And so these cases, and I'll touch on them briefly in relation to the big organisations like 7-Eleven and like Woolworths. The decision maker comes down really hard on those really big organisations, because there's an expectation that they are well resourced and that these things should not happen. Whereas with the smaller businesses, there's a little bit more sort of leeway given to them, but it doesn't mean that you shouldn't be taking these active steps that we'll talk about in a bit. So
I'm just going to chip in there, though, just to remind our audience that the Chamber, of course, runs a workplace relations service. So we have an employer relations assist team in the business. You can give us a call on our 1300 number. We'll be happy to help you through questions you might have. And of course, we've got members like MV Law who are also available to provide assistance. So.
Absolutely. And what a valuable resource that is, because it's hard enough trying to get in line with all the other regulation that's going on. And as I say, employees are the very best and worst of your business. You need them to be able to be successful, but the way that they're the worst is why Ryan and I have a job. So it really is about making sure that you have and you use these resources like the Canberra Business Chamber to educate yourself on all matters relating to HR. So very excellent resource.
Anyway, sorry, carry on.
That's right. Yeah, so Ryan's going to give us a little spiel on how this new provision in the Act, which commenced on the 1st of January 2025, how it works. And then we'll move back to me for me to talk about some of those bigger case examples. We're going to talk about some self-reporting, the self-reporting regime, and we'll finish up with the voluntary small business wage compliance code. And then obviously we've got the questions. So
absolutely.
Take it away, Ryan.
So yeah, as Amy said, they are quite recent changes. They did come in on the 1st of January 2025. They were introduced under Section 327 A of the Fair Work Act. And as we've said, there was already the civil penalty regime that existed under the Fair Work Act, and now this introduction is in relation to the criminal regime. So something that you touched on at the commencement of the chat, Greg, was that it really does revolve around this intention element, and it involves any conduct that an employer engages in or intentionally engages in that results in the underpayment to an employee of a required amount, and that required amount will include wages, but it does also include superannuation and any other payments for entitlements such as long service leave or annual leave.
Does that include, just to clarify, if you're making payments intentionally late, for example, superannuation, if you're holding those payments off because you've got some cash flow problems in your business or something, that would get caught within the definition?
It does, yes, it does capture it. So the wording under the Act is that the payment, it's on or before the date that the payment is due. So late payments can still be captured by that. If it's done intentionally, then it may come within the scope of the regime as well. So really what it comes down to is that fault element, which is crucial for the criminal regime. And it's, as we said, that intention, if an employer is doing that. Accidental underpayments, again, may be captured by the civil penalty regime. The fines and the penalties involved with that are obviously much lower than the criminal regime. But it's really trying to stamp out employers, as we said, in those larger scale organisations, or to prevent these employees deliberately not receiving what they're supposed to receive. Now, there's no minimum payment that needs to be met. There's no threshold in that regard. It's any payment that is owed to an employee, a required amount that's not paid, enlivens that provision. So there are, as we said, quite significant penalties that are involved. They can apply to both an individual and the corporate entity. So where an individual can be shown to have been involved in that deliberate conduct or that intentional underpayment, directors themselves can become an accessory to that and be liable for the individual penalties. Now, as Amy said, imprisonment is one that can happen. Now, these are maximum penalties that are under the Act. So depending on the nature and the scale and all the various factors involved with the underpayment will determine which sanction is actually applied. So if people do read this and see that there is a potential individual penalty of 10 years imprisonment, that is for your most egregious of breaches. But an individual, as we said, if they can be found to have been involved in the breach, it can be imprisoned for up to 10 years. There can also be a financial penalty that's involved in of up to, it's approximately $1.5 million. Or there can be a combination that you can receive both. An individual can be imprisoned and also receive that fine. Alternatively, if the court can determine the amount of the underpayment, then there may be a financial penalty of 3 times the amount of the underpayment, whichever is greater between the underpayment and the 1.5 million.
So that's potentially quite significant.
Very, very significant, very serious.
Yeah.
And the same applies to there's no imprisonment involved with a corporate entity, but there is a fine of up to approximately $7.8 million for the most egregious. That's your maximum penalty, or again 3 times the amount of the underpayment if the court can determine that. And when you look at cases such as Woolworths, where the underpayment was approximately 300 million over the course of 8 years, 3 times that amount is potentially very, very serious as well. So massive penalties that have come in really to try and stamp this out, particularly, as we said, if it's deliberate and intentional, really try and knock that out under this new regime.
And we must say, I just wanted to add here as well that we're obviously talking to an ACT audience here, Greg, because this is the Canberra Business Chamber. So we are talking in the ACT context. The Fair Work Act does not apply to every single employee in Australia. It applies to every single employee in the ACT, definitely. So if we've got people looking at this from New South Wales, for example, or South Australia or Western Australia, there might be some employees in those jurisdictions, particularly if they work for council or the sort of lower level government councils and things like that, they may not be captured by this. So just to reiterate that when we're talking about superannuation, for example, that only applies to a superannuation by an employee who is a national system employee, and that is everyone in Canberra. So for everyone watching here is a member of the Canberra Business Chamber. Make sure that you are compliant with every single every single obligation, but in this context, every single financial obligation towards your employee under the Fair Work Act, and you'll be fine.
Excellent. So, do you want to tell us a little bit about some of the cases that?
Yeah,
have
absolutely. Well, so we're talking about a regime, the criminal regime that's only coming on the 1st of January 2025, as we said. So there are no reported current cases under that regime, civil or criminal, at the moment. Having said that, we can have a look at some of the examples of the big notorious cases, just so your members can be assured that these are the types of cases that I think that would have enlivened these criminal sanctions if those criminal sanctions existed back then. Because an important thing to note about this, these new sanctions is they are not retrospective, so they do not apply to behaviour that has occurred prior to the 1st of January 2025. So if you've got members sitting there going, oh my gosh, I've been meaning to get onto this, I had someone come and say something to me about, a year ago and I haven't looked into it. Sure, if you start to do some of the steps that we take, including what we'll talk about later, which is to self-report, you may be caught by some of the civil penalty provisions and there may be an instance of a possibility of a fine, but you don't need to worry about these criminal sanctions applying because the behaviour didn't occur after the 1st of January. But we can still look, and this is what lawyers do when we have new regimes, so we can still look at previous cases to say, well, what are the courts likely to do? And here we've got, and here I have to have a little bit of my notes, apologies, but we've got some figures, facts and figures to come out of this. So what I wanted to talk about first, if I can actually find my facts and figures, which of course maybe I can't, is the, here we go, wrong bit. So the 7-Eleven case, which as I said before, kind of kicks this all off. So here we've got, there was found over a course of 5 years, we've got underpayments of $173 million worth of underpayments, which were historical over a number of years and slowly paid back by 7-Eleven franchisors, or the franchise, over a period of 5 years. There was, this was underpayments to more than 4,000 employees across their franchise. And notably, it was found after a very significant investigation by the Fair Work Ombudsman that there was also behaviour of the individual franchisees falsifying records to hide the underpayments. So those sorts of behaviours would absolutely fall within this criminal regime. So they're actually, in my opinion, they're lucky it was found out back then, and they've had some significant fines against them and some other sort of sanctions that they've had to work through. They've entered into a compliance agreement which requires them to do a number of things on an ongoing basis. So that is costing them money to do that. They've spent $10 million on business improvements in response to this. Not only that, they've obviously paid back that $173 million. So you're not going to get out of paying the amounts that your employees owed. You're also going to have fines on top of that. And the figure that they were paid across, I think there were 11 prosecutions that this case involved, $1.8 million in penalties. And that was when the penalties were much less than what they are now. So you've got much more significant civil penalties as well under the current regime. So that's the sort of behaviour that we're looking at. Not to say to your members, hey, let's not worry about that. I'm not Woolworths, I'm not 7-Eleven, but we want to make sure that we are demystifying this for you. And it's another thing that is protecting employees legitimately and particularly vulnerable employees. The 7-Eleven employees, a lot of them are migrants coming out here and getting those jobs in the 7-Eleven supermarkets and petrol stations, and really taken advantage of very, very intentionally. So that was just a horrific case.
And let's just be clear on that. So it is absolutely correct, isn't it, to say that a migrant worker or someone here on a temporary visa has the same rights as every other worker here in Australia.
Absolutely. So regardless of whether you're covered by the Fair Work Act because you're a national system employee, or you're covered by one of the other generalist, industrial relations acts in New South Wales or elsewhere, your rights as a worker, regardless of your nationality, where you've been born, that sort of thing, covered by those. And in fact, we've advised clients who are operating overseas, and because they're a national system employer, their overseas employees are also covered. Or they might have their hub overseas and they've got employees who are here either working remotely or they've got small satellite offices here in Australia. They're covered by the Fair Work Act as well. So really, really important to understand that there's very little opportunity in business to get away from these things. And that's the whole, the whole design behind the closing loopholes. It was, we found these loopholes, we're going to close them, because these are ways that employers have found to get away from their obligations. So very, very important that these obligations exist. But of course, the government will say, and of course, as the Canberra Business Chamber, we want to say, we want to demystify this, because we don't want this to be a barrier, yet another barrier to successful business.
Absolutely.
Yeah, so right.
So we've kind of got to get everyone on the right page, so we know what we're doing and we're meeting the legal requirements, because that's the key.
100%, absolutely. So education and proper advice and all of that sort of thing is really, really important. And of course, your members will be finding the assistance they can get from the Canberra Business Chamber as well. So important to have those teams, those people on your side, because it's a team effort to run a business. So absolutely. Now, I'll just touch very briefly. Ryan mentioned the Woolworths matter. That's much more recent. So this was from 2018 to 2023. Woolworths ended up receiving a $1.27 million fine. And what was really interesting in this and relevant to your members, Greg, is that the Fair Work Ombudsman found that there was systematic and widespread failure to prevent this from happening. And that is really where that intentional element comes in. So it's intention to do it, but it's also intention to do nothing about it. Do you know what I mean? So
once you know there's a problem, or just not having the system.
Yeah, you can't. I think you can't turn a blind eye to it. So I mean, Ryan, you'll correct me if I'm wrong here, but the intention element is, it's there to protect those really inadvertent breaches. And if you've discovered a breach and you haven't done something to prevent other breaches from happening or to fix that breach, then that's intentional to not deal with that particular breach, even if the original breach was unintentional. So really making sure you're being proactive in this space and making sure that once you do find something that might not be right in your business, you really do investigate it. You must investigate it. You must approach that and make sure that you're dealing with it appropriately. But Woolworths was found to have not looked at this as proactively as possible. It came about because in 2014 they changed their payroll system, but they didn't do an audit of that payroll system until 2020, and that was approximately a year after they first started to see some red flags. So and again, I talk about this such big organisation, it was found that they should really have had these systems in place, and they didn't. And so that was a big slap on the wrist for them to be like, you guys should know better. You've got your big HR department. You've got the time to do the proper audits. You need to do it. So again, another example of a big business and a big case that, had it been prosecuted, had the behaviour still been happening now, and had it been prosecuted post 1 January 2025, I absolutely think this would have been a test case for these provisions in the criminal space. So, yeah. Yeah, so now, Ryan, you were going to have a chat about the self-reporting. This is one of the tools that you can use as a business to, one of the maybe slightly more scary tools, but one of the tools that you can use as a business to make sure that you're compliant with your obligations.
Yeah, and absolutely. It touches on a couple of points that were raised before. It's once an employer comes into knowledge that they may be breaching these, it's really important to be proactive about it. Because the second that it may be an accidental or inadvertent breach beforehand, once an employer finds out or an employee comes to them and says, hey, I think I might be being underpaid, then it may be a bit more difficult to overcome that intention element. And that's what may enliven criminal sanctions at that point, if you, as an employer, sit back and not do anything about it. Now, there are a range of mechanisms, and we'll touch on a few. One of the primary mechanisms that employers can engage is to self-report an underpayment. Generally, if it's more of a systematic underpayment, if there's something that's wrong with the payroll system, then, and if it's over a sustained period of time, for example, then employers can report and provide a full and frank disclosure of the underpayment to the Fair Work Ombudsman. It'll generally be viewed quite favourably, that particularly if you compare that to an employer who tries to hide this and continue to under.
So is there an obligation to self-report, or is it a voluntary?
It's not mandatory. It is something that employers can opt to do. Generally, depending on the circumstances, would probably advise to do for those larger scale.
So it should rather than a must.
Correct. Correct.
Yeah.
Yes. And so, if an employee, say to use quite basic examples, if an employer receives information from an employee that maybe they've been underpaid small amount of money in one pay cycle, then that's probably not the kind of thing that you're looking to self-report. If it's more of that systematic underpayment, if there's an issue that's come up, maybe you've heard things from multiple employees, or you've discovered information without anybody raising anything that indicates that there's been a sustained period of underpayment, then going to the Fair Work Ombudsman and reporting that and providing that disclosure is going to be viewed quite favourably. It can encourage the Ombudsman to enter into a cooperation agreement with an employer. If a cooperation agreement is entered into, then the Fair Work Ombudsman won't refer the matter for criminal prosecution. Fair Work Ombudsman, if there is criminal prosecution that they're going to refer, they'll refer it to the DPP or the AFP to prosecute. But if there's a cooperation agreement in place, then that won't happen. It doesn't prevent the civil penalties being applied, but it does remove that criminal liability if an organisation self-reports, which leads to an agreement with the Ombudsman.
Yeah, one of the other things to mention about that is I've just lost my train of thought. We were talking, so the Ombudsman has actually issued a compliance and enforcement policy, which gives their views on how they operate in this space, and it's probably quite an important document for your members to have a look at. There's a lot of great information on the Fair Work Ombudsman website about this, a lot of really some free tools, and we'll touch on a few of them. But this compliance and enforcement policy changed some of the wording around the guidance around when a business should report through self-report. So it changed from sort of a broad and systematic failures to broad and historical failures. So there is some commentary around that there's a recommendation that if you find an historical breach, no matter how unsystematic or small, that the Ombudsman expects you to report that. So we're talking a breach that's say more than 12 months ago. There is guidance in that compliance enforcement policy that suggests that the Fair Work Ombudsman is not really interested in those really one-off isolated cases that might even last for an employee for 12 months, for example. If that employer is proactively dealing with that, they don't need to hear about that. But if you discover that there's something that's much more historical than that, or much more systematic and broad across your organisation, absolutely, like there is an expectation, not a legal requirement, as we said, but these are the things that the Ombudsman wants to find out about, so that the Ombudsman, you can almost see the Ombudsman as an organisation that can help you as a business to unpack the breaches, work out how to rectify them, all of that sort of stuff. And there are circumstances where, if that's the case, and you're a small business particularly, who has shown genuine reasonable steps to actually try and avoid these things, and you've stumbled across something and you're like, okay, my payroll system was set up incorrectly 2 years ago or something like that, and you're then showing genuine remorse for it and wanting to fix it and pay back, there are other things that the Ombudsman can implement instead of fines, and certainly instead of a criminal brief to the DPP, and that is things like enforceable undertaking. So a promise from the organisation that this won't happen again, or these are the steps we're going to take to make sure this doesn't happen again. And those enforceable undertakings can then, if they're breached, can then be taken further by the Ombudsman. But it's just one sort of intermediary step, so that you may think to yourself, well, if I self-report, I'm going to get fined. Not necessarily. If you don't self-report and you continue to stick your head in the sand, and then it's found out by the ombudsman, absolutely you'd be fine.
So you're better off really to
Yeah.
pull your head out of the sand, fess up, and
Exactly.
do the right thing.
Exactly.
Yeah.
There is an ability for employees to submit an anonymous tip. So there is always that risk that that may happen. Your employees can put that forward, and you can get found out even if you are a small business. There's certainly mechanisms for you to get found out by the Fair Work Ombudsman.
Yeah.
So I understand there's a voluntary code for
Yeah.
the Fair Work Ombudsman has
Yeah,
put out.
there
Do you
is.
want to talk to us
Yeah,
about that?
absolutely. This is the Voluntary Small Business Wage Compliance Code. It was brought into effect. It's an instrument under the Act, so it's a legislative instrument under the Fair Work Act that was brought into effect on the first of January 2025. And what this is it's almost like a tick box step-by-step guide to business of how do I do the right thing in this space. And like other codes in the Fair Work space, it's voluntary, so it's not mandatory for you to follow it. But if you are a small business, so fewer than 15 employees, and you are found by the ombudsman is satisfied that in a specific case where there's an allegation of underpayment, that you have actually followed that code, then the ombudsman cannot refer that to the DPP or the AFP for criminal prosecution. So as a small business, it is your very best armour and protection against criminal prosecution. Now, that's not to say that it's not a really great guide for big business. It gives you the guide of how do I comply. So just like other codes in this space, we often do encourage even our big business clients to have these codes almost as a Bible, because while it's not going to be a definite outcome that compliance with the code won't mean criminal prosecution, it's a pretty safe bet, because it really does. It's the legislature along with the regulator working to say, okay, what are the steps that we think need to be taken in order to actually have compliance?
And what sort of things are covered in the code?
So firstly, as I said, it's voluntary. In order for a breach to be found to be in breach of the code itself as well, it has to be intentional. So there's an intentional element. But it also talks about the things, as I said, the steps, the things that are expected to be taken. So the tick boxes of like, if I'm doing this, then I'm compliant. So if there's an investigation that goes to the Fair Work Ombudsman, they will look at this as step one, particularly for small businesses, of this is step one, let's see if you comply with this. So did you take reasonable steps to prevent this sort of things happening? What are some of the proactive things that you as a business have done to make sure that you're not underpaying your staff? One of the things that Ryan and I were discussing this morning was the grey area of how are we seen to be proactive by informing our staff about their rights without actually triggering a complaint from a staff member or getting them to proactively start digging around in their pay records and their pay slips. And we think in this circumstance, actually having the conversation with your employees, giving them information about their rights and telling them these are the things where we know we have these obligations and we absolutely want to make sure that we are compliant because we value you as an employee and we also don't want to be criminally liable or civilly liable for this. But it allows you to have a conversation with your employees because your employees can be your best information about whether or not something's going wrong in your business. And if you have an open conversation with your employees about that, you'll find out about them sooner. You'll be able to rectify them sooner. So it might just become an isolated problem that is not one that you should self-report. And those cases can be shown in subsequent cases as the way that you're proactively working. So these reasonable steps, these practical reasonable steps to avoid breaching the obligations under the Fair Work Act are really important. And there's a list of some of them that are seen to be recommended. It's also about making sure that you are making assumptions about pay on reliable information. So do you know whether an award applies in your business? If an award applies, do you know where your employee sits in that classification in the award? So are you paying them correctly according to what they do in your business? And it's so incredible, Greg. So many of our staff our employer clients come to us. And one of the first questions we have to ask them is, does an award apply to your business? because they know their business better than us the minute they walk in the door. And I reckon it's got to be 50-50. I reckon 50% of them say,
Really?
I've got no idea, no idea. And so those people are at risk of falling foul of these obligations because they don't even know where the baseline is for things like penalty rates, minimum wages, all of these sorts of things. So you need to make sure that what you're basing your staff's your contracts on, or your weekly wages or hourly wages or whatever it is accurate and reliable. And so that comes down to the next thing in the code, which is really about making sure that you have those partners, you're relying on other advice and information. So I mean, you've got your HR service for your members, but reach out to an employer. If you don't have an HR unit within your business, which many of your members I'm sure don't, see if you can build a rapport with a lawyer where you can reach out to them as well, because one of the things that your members or employers generally in Australia will probably struggle with is when they do discover the underpayment or the issue, do I report? And it's always good to run that past, get that advice. But if you're actively seeking this advice and this information, then that's going to be absolutely a great part of the defence if you're ever looked at or focused on by the Ombudsman.
Yeah. And ultimately, I mean, my view is that all employers, or certainly the very vast majority of employers, want to do the right thing. They want to have an engaged workforce. They want to have people who are happy working. And you don't get that if you're systemically underpaying.
That's exactly right. Exactly right. And that's why that links to what I was saying previously about having that conversation with employers, because you've got to hope that, in the ACT, for example, we've got 99.9% of businesses that want to do the right thing. So if you want to do the right thing by your employees, then there's no risk in having this conversation with them, because any mistakes that you've made would be genuine mistakes, which, as Anna Booth, the Ombudsman, has said, they're not going to be prosecuting, and things that you can fix.
All right.
Yeah.
So tell me, are directors and senior managers, are they personally liable as a result of intentional wage theft or super theft? At
times, yes, they can be. Yeah. So there are certain provisions, the civil penalty provisions under the Act, which can apply to the organisation, and as Ryan was saying, to the individual directors or the people that are found to be involved in the breach. So it's not uncommon for us when we're acting for an employer and the employer client says, here's an application that's gone to the Fair Work Commission, and you see, that they have listed the organisation as well as all the people that made the decision not to were entering into breach. And it can be scary. But of course, it's there for a reason. You can't hide behind the corporate veil in this circumstance.
So how do you, if you're a manager or a business owner, how do you protect yourself?
Do you want to talk about that?
Yeah, sure. So I think we've probably touched on a lot of the steps that individuals can take on behalf of their business to avoid liability. I think the overall message for a lot of this is, as Amy was saying, is to be proactive and get on the front foot before this kind of thing happens. And even if you don't believe or you know that you're not underpaying anybody and your payroll systems are all up to scratch and everybody's happy, even just something as simple as providing employees with the relevant information about what their rights are can kind of get you ahead of the game a little bit. It's really trying to show various steps that you've taken to avoid any liability in these instances. So again, as we've said, because intention is such a prevalent factor of the criminal regime, as soon as you become aware of any possibility that there is an underpayment that's occurring in your business, engaging with the employees directly if it's maybe a one-off to try and resolve the situation, and then having some more institutional changes within your business as well if it's necessary in order to just stamp those out. So at least, I know a lot of what we're talking about is the new regime, the new criminal regime. I know we keep saying the word intention, but it really is kind of the crux of the whole provision. And instances such as self-reporting, using those mechanisms to prevent that from being in breach of those provisions is crucial.
Yeah, so intention's obviously critical to this, but can you insure against the risks here?
You can. You can get management liability insurance, absolutely. And maybe many of your members might already have this, but critically, what this doesn't insure against is the actual underpayments themselves. You can't say, I'm just going to sit there as insurance and I'll start underpaying so that the insurer is going to pay for it. It can kick in to help you with legal costs and dealing with the Fair Work Ombudsman, and then possibly any fines that come out of this. So it might be something particularly for bigger businesses where the directors don't have full control over what's going on underneath them, to possibly think about getting that. But the only other insurance really is the insurance of making sure you take these proactive steps. So there are some really great tools on the Fair Work Ombudsman website, and I encourage your members to go to the Fair Work Ombudsman website about this. There's links to the code that we just discussed. There's also the compliance and enforcement policy, and there's this really fabulous, which I brought along. We brought along a few in hard copy, but all your members are online. But it's the Guide to Paying Employees Correctly and the Voluntary Small Business Wage Compliance Code. So absolutely go and have a look at those tools. There's a really fabulous tool, which is like a wage calculation tool on there as well. Don't rely on them 100%, but they're good to give you a guidance where you need to be at. There's also a tool about finding your reward. So again, making sure that you plug in, this is the industry I'm in, these are the employees that I'm engaging in, and that can pop out an award that should apply. Getting legal advice about this, but we can't highlight enough. It really is about consistent auditing of your systems and processes, auditing your wages that you pay every year, particularly around May to June, when the Fair Work Commission makes its minimum wage decision about the increase in the minimum wage. And we recently had an increase of 3.5%, which I'm sure your members all completely are on top of and are probably feeling that it's going to impact them come 1 July. But what happens when that happens is all of the minimum rates within the awards all get boosted. And so particularly if you're an employer who is paying at the minimum rate, that is going to be something you're going to have to do every year to make sure that those employees are getting that pay rise. But even if you're not using the award as your contract with your employees and you've got a contract, making sure that you get that reviewed by a lawyer fairly regularly. I would suggest maybe every 3 to 5 years, because some of the changes, particularly some recent changes, really require changes to your employment contract. And if you're still sticking by your employment contract, you could be falling foul of these obligations and others in the Fair Work Act without really knowing about it. So again, that's where you have that risk of particularly civil penalties, the fines, and obviously if it's intentional, you've then got the risk of criminal sanctions.
Okay.
Yeah.
So, look, times obviously are a bit tough at the moment. We're in a difficult economic situation. There's a few businesses out there in Canberra, I know, that are kind of on the brink of having some real challenges.
Yeah, we spoke about it. They were speaking about it yesterday at the event.
You know, if you're a business that really is stretched for cash and you're faced with a choice between paying your employees or paying your suppliers or paying your rent, and you're tempted to think, if I just delay some of those super payments by a couple of weeks, what's your advice around that?
Don't do it.
Basically, yeah. You're leaving yourself open for breaching the Act, and that's what we want everybody to avoid. We don't want anybody, we would never advise anybody to put themselves in that situation. It's just something that you wouldn't even want to try.
Yeah. You need to get on top of those issues as quickly as you possibly can, because if you're going down the path of not being able to afford supplies to run your business and the employees, then unfortunately that's red flag for insolvent trading, and particularly if you're a proprietary limited company, there's those obligations to directors, all that sort of stuff. And getting on top of that really soon, employees are very much protected under the Fair Work Act, like 100%, and these closing loopholes provisions have protected them even more. But there is a recognition particularly for small businesses, fewer than 15 employees, that there are going to be hard times. And so that's where things like redundancies can kick in, things like that. But it's important to make those decisions with the proper legal advice so that you set yourself up for being fully compliant. So we always say to our clients, you can never stop your staff or anyone from commencing proceedings, but you can make sure you set yourself up to head there with as clean hands as possible. So,
right, some great advice there, which I think, if I'm going to sum up, it involves really know what you've got to do in terms of paying your people.
yeah,
Make sure you do it, and if there's a problem, fix up and fix it.
absolutely.
Excellent. It's been great having a chat this morning.
Thank you.
Amy Sidney and Ryan Goldsworthy from MV Law, thank you so much for joining me. If anyone's got any more questions, just fire them through to us at info@canberrabusiness.com or check out our website for connection through to our employment relations advice line. I hope that's been really useful for you, and thank you so much for joining us.
Thanks for having us, Greg.
Thank you.
Thanks.